Thanks for joining us. So we are doing this webinar, but also having few people on site so that we can encourage discussions. And you will be also able to ask any question you want, write in your questions, and at the end of the presentation, you will all be able to speak. You will be unmute for this purpose. Don't worry, you are not going to have to get used to my accent. I'm not the speaker today. I am the co-leader of the SME committee with Madeleine, who should be joining us online as well. I am working at Hesketh Henry, and my colleague Alison and Eloise are the experts on employment law, and they are going to be the one giving the presentation today. So I will leave it to both of them now.
Thank you. Thanks, Zoe. So I'm Alison Maelzer, and sitting beside me here is Eloise Callister-Baker, and we are both employment law specialists in the team here at Hesketh Henry. So we advise primarily employers, but the occasional employee and also the odd union as well about employment issues. So we cover the full sort of spectrum, if you like, of employment issues. So if you need an employment agreement drafted, we can help you with that. And if someone's raised a personal grievance, then we can help you work through that process as well. The things that we wanted to just cover off today, or just have a chat about ideally, and hopefully this format won't make it too much of a sort of lecture style presentation. Feel free to pipe up, even if you're online, if you've got a question or a comment, or if something doesn't make sense, then please do speak up. We want this to be, you know, just a casual conversation. I don't want to be lecturing for an hour. So what we're covering off today is the massive topic of COVID-19 and employment law, which is obviously a hugely broad sort of a category. COVID-19's pretty much touched every aspect of everyone's lives, unfortunately, and employment law is really no exception to that. It's been a pretty wild ride for us in the employment law arena. I think it's fair to say there were a few weeks and days there, particularly while we were in lockdown, where we just honestly didn't know what was going on, and we were in this weird situation of trying to fit some really strange factual circumstances to a normal legal framework, and the two just didn't really jibe all that well. You've got the government making rules and schemes and situations on the fly, and obviously when that happens, things aren't going to be 100% perfect, and they're not, as I say, always going to align with the rest of the legislation that's in place. And with employment law, that was really kind of obvious, and Eloise will talk about this a little bit in a minute, about when it came to the wage subsidy scheme and normal employment law principles around being ready and willing to work, and also things like Holidays Act entitlements as well, so sick leave and annual leave and what have you as well. So the things that we want to focus on today are, I'm not moving to the next slide.
If you click on the slide, maybe, because it wasn't in, yeah, and then.
Look at that, thank you. We're going to have a look at redundancy and the process that needs to be followed in New Zealand if a redundancy is being considered. Sadly, that has been very much a feature of the last 6 months, I suppose we're at now, isn't it? Madness. And without wanting to be all doom and gloom, I suspect that there are still a few redundancies yet to come, unfortunately. So it is an area where it's really, really important to take the time to get the process right, because you can have the best sort of reason for redundancy in the world and still end up with a personal grievance that you're not able to defend because you've stuffed up the process. and it seems like a real sort of wasted grievance. We're also going to have a look at a couple of the cases that have come through about COVID-19 already. And then something slightly more positive, working from home issues. So how companies can deal with the different employment law issues that come out of people working from home. So without further ado, redundancy. So first of all, the idea of what redundancy is, it seems kind of obvious, but it's got a few elements to it. So when we talk about restructuring, what we're normally talking about is changing the way a business is structured. So internally, the way a business is structured. You might have a manager up here and a bunch of managers along here, and then a bunch of workers, if you like, underneath that. And you might decide maybe that you've got too many managers in that middle level, or you don't have enough people at the top of the tree and you need to switch that around. So that's what I would describe as a restructuring. Restructuring might cause the disestablishment of a position. So you might decide that actually you've got 30 people along the bottom and really you only need 20 because your orders have dropped or you're not able to export stuff or whatever. So that may result in the disestablishment of some positions. And then disestablishment of a position might result in that person's employment being terminated for redundancy. So if their position is no longer there, then they might not be able to find another alternative position within the company. And in those circumstances, you might end up having to terminate their employment for redundancy. So restructuring might lead to disestablishment, which might lead to redundancy. Yeah. So there's no actual sort of definition of what redundancy is in any statute or any law. The normal definition that's sort of come out of years and years and years of case law is a situation where your employment gets terminated because your position is no longer required by the employer. So there's a couple of key elements there. One is that it's the position, not the person. So a redundancy occurs when the position that the person performs or occupies is no longer needed by the employer, which means that we're talking about not the characteristics of the person within the role. So specifically not that whether they're a great performer or a terrible performer or whether they're doing really well or not doing really well. It's about whether you need that actual position. So you need to divorce the position from the person occupying it. And sometimes that's much easier said than done. It can be difficult to figure out whether you genuinely don't need that position anymore or whether you just need someone who can actually do the job better. And sometimes it's not always that clear cut. The second thing is that the position needs to be superfluous to the needs of the employer. So the position is no longer needed by that employer. And that can happen in a number of different ways. So common sort of reasons why a position might not be needed, perhaps you're not going to do that type of work anymore. And in COVID times, that's relatively common, that perhaps you're not able to do a certain type of work that you were able to do before. And obviously when you're thinking about hospo and the tourism industry, there'd be quite a few things that would fall into that category. Contracting out, you might be deciding that we've been employing people to do this job, but actually it's going to be more cost effective if we can engage a contractor outside of the company to do that work on maybe on an ad hoc basis. So you might outsource some work to a freelancer, for example. You might have a situation where you're merging two or more positions. So you've previously had a sales manager for the North Island and a sales manager for the South Island. Because you've got a reduced number of orders and a reduced workflow, you think, well, actually, we probably only need one national manager for the whole of New Zealand. So that would be a circumstance where you're merging two positions into one. Alternatively, you might think, hey, that New Zealand sales manager has actually got way too much work to do. We need to split that role into a North Island role and a South Island role. So in those circumstances, you are still going to be having a situation where the New Zealand manager role is no longer required by the company. So it's still a disestablishment, and you're going to need to figure out what happens to the person in that role. As I said before, you might be reducing the number of the same positions. So you might have 5 accountants and realise that really you only need 2 or whatever. And unfortunately, again, not that uncommon in COVID times, you might unfortunately be selling or closing the business. And in those situations, it's likely that none of the positions will be required by the employer. Although it might be a situation where you're closing part of the business or a certain aspect of the business. It gets more tricky when you are thinking about rearranging functions or taking away some duties or changing reporting lines. That can be a situation where you're changing someone's position. You're not doing away with it entirely, but if you're changing someone's position so significantly that really you look at it and you say, actually, you know, that's not the same job as what they were doing before. And that can lead to a redundancy situation as well, because essentially that original job is superfluous to the needs of the employer. There is another job, and that's great, but you still need to work through the process of consultation.
Can I ask a question?
Of course you can, Zoe.
You will have to evidence all of this to your employee, the fact that position is not required anymore, and on what basis?
Yeah, absolutely. So that's exactly right, Zoe. If any of these reasons are going to need to be explained to the employees, and we're going to need to work through a consultation process, which I'll come to in a second, which it puts forward all the information about why you're considering doing what you're thinking of doing. So why you think you only need 2 accountants instead of 5 accountants, why you think it would be better to have a North Island and a South Island manager, whatever. Yeah? And at the end of the day, as with all dismissals, the test for whether it was a lawful dismissal or not is governed by the same test. So whether you fire someone for punching someone or stealing money or being a terrible performer or making them redundant, the test is the same. It's whether the employer's actions and how the employer acted were what a fair and reasonable employer could have done in all the circumstances at the time. So there's a real element of kind of what would a fair employer do in the shoes of this employer. It doesn't mean that if you don't tick every single box and you don't sort of go through an extremely rigorous process, you might not get away with it. We can provide the slides after if you like. That's probably going to be easier. Yeah, I think you won't get my head in the corner of the shot. Yeah, so there is some sort of scope to for employers to have a little bit of a hiccup in the process and not be found the whole dismissal to be unfair. But generally speaking, the courts are going to expect to see a fair process that's followed. So that's how the employer acted. The other thing is that good faith is going to apply whenever you're considering terminating an employee's employment. So good faith's got a number of elements to it. One is that you're not allowed to lie to your employees. That's quite important. Equally, your employees aren't allowed to lie to you. So it's important that you have that relationship where you're not misleading and deceiving each other. The other aspect of it is that, and as Zoe mentioned before, there's an obligation to provide all relevant information to the employees about the reasons that you're considering terminating the employee's employment. And we'll get to that in a second as well. Yeah, so as I mentioned, we've got 2 sort of elements: how the employer acted. So this is, what the employer did, which is the substantive reasons for the redundancy. So did you legit only need 2 accountants instead of 5, and then how it is carried out. That's how you went about the consultation process. In relation to genuineness, so whether you legitimately were able to do that or legitimately able to make that decision, there is a management prerogative. So employers are, generally speaking, allowed to run their businesses however they want, right? They are allowed to decide that actually we'd be more efficient if we did this thing over here, or if we had less managers, or if we had more managers or lower managers or fewer accountants or whatever. Employers are generally allowed to decide those things for themselves. It's not for the court to step in and say, well, actually, you'd run a better business, and it would be a better business if you had more accountants or if you had fewer middle tier managers. That's not the court's role. The court will look to make sure that there's some logic to the employer's decision. So if the employer is saying, this would save us money if we did this restructure here, and the court looks at it and goes, well, actually, it clearly wouldn't, because you're clearly going to be increasing your costs here, then that would really cast some doubt on the genuineness of what the employer was trying to do. So the court's not going to say that's a really dumb business decision, but they will say, hey, that doesn't add up, that doesn't make sense. And if it doesn't make sense, then as an employer, you're going to be sort of on the back foot trying to explain, well, yeah, I still need to make that person redundant. And it starts to look a bit iffy, like maybe you were getting rid of them for some other reason. Oops, the slide's gone a bit awry there. So common examples of substantive reasons you can see up on, well, you can sort of see up on the slide there. Economic downturn, obviously that's a big thing at the moment. Sometimes the opposite can happen. If your business is growing, it can be a situation where one person has previously done everything and you want to disestablish that role and create a bunch more specialised roles to do more stuff. So growth of a business can actually result in redundancies as well. Changes in technology, I think we're all sort of experiencing that for better and for worse sometimes. Relocation of a business can result in a redundancy, and of course selling your business is going to result in at least a technical redundancy. Woo. So skimming on to the process that's required. This is just really an overview of the process. So your first step there is going to be to develop a proposal. You're then going to need to receive feedback from the affected employees. You're going to need to consider that feedback, make a decision, think about whether there are any alternative positions available, and only then will you be in a position to terminate employment. So you've got a wee path to go through before you get to the termination stage. And where we see it go really, really wrong is when an employer calls us up and says, I don't need this person anymore. I'm just going to call them into my office and tell them that they're redundant, kind of Trump styles. Sorry, you're fired, is not going to cut it in New Zealand. Even if, as I said before, you've got the best reason in the world to make someone redundant, if you don't go through the process, it's going to be an unjustified dismissal. How long does it take usually to go through the process? What would you say?
A very fast process, potentially 2 weeks.
Yeah.
But usually over a month, maybe.
It really depends a lot on how complicated the proposal is, how much information there is to digest, and how many employees it affects as well. So if you've got like one person that it affects and it's a really straightforward proposal because you're going out of business and there isn't going to be any more jobs, there's really not going to be a great deal of consultation to be done. But where you're doing something really complicated and you're changing things around and merging positions and disestablishing other positions, then yeah, as Eloise says, you can expect that to take a fair bit longer. I had some time working at Auckland City Council, and I can tell you that local government consultation processes are going to take significantly longer than that, because then you've got a zillion people to consult for a starter, you've got multiple unions involved, you've got the fact that everyone needs to go home at 4:30 every day. It just gets really, really complicated. So there's no sort of set time that it's going to take. What you need to start with is a proposal, and that's a proposal instead of a decision. So you can't have made a decision to create your one North Island role or your one national role. You can't have decided that you only need 2 accountants. You need to have a proposal. So you need to be saying, we think that it would be more efficient if we had 2 accountants instead of 5 accountants. And the reason that we think this is blah, 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 insert genuine reasons here. If you've got a bunch of board minutes that say, we the directors approve a reduction in headcount of 10% and we want this role gone and this role gone and this role gone, that is really good evidence that you have not started with a proposal, that in fact you've started with a decision, and anything that the employees say in the consultation process is really not going to make a lick of difference, and your process is almost certainly going to be unjustified, and that the dismissal will be unjustified as a result. So it's really important that you kind of try and rein in the powers that be within your organisation and make sure that there's no evidence, at least, of a decision having been made already. So it's fine to make a decision to consult about a proposed restructure. There needs to be a decision made to actually commence a consultation process, but that should be the decision rather than a decision being made about what is actually going to happen out of the end of it. So when you're figuring out your proposal, you need to be thinking about the why. So, what I tell clients is that a proposal is really quite simple. It doesn't need to be fancy. It doesn't need to be glossy, although we've got some advertising clients who always do these real glitzy processes. You need to be talking about what you're proposing and why you're proposing it. Simple as that. What are you proposing to do? Why do you think that would make things better? You need, in terms of the what are you proposing to do, you need to talk about what roles would be disestablished. You also need to think about any other impacts to people's roles. So whether their reporting lines are going to be changed, whether they're going to be proposed to get more duties or fewer duties or different duties, or they're going to have a wider geographic scope to cover, or whether they're going to need to travel more or travel less, or whatever. So those impacts need to be considered as well. If you're looking to reduce a number of the same positions to a smaller number of positions, so that's my 5 accountants to 2 accountants example, you're going to need some selection criteria, so some means of figuring out which of your 5 accountants are going to be the lucky 2 and which are going to be the 3 that drop off the end. So that selection criteria is something that needs to be up for consultation as well, so that needs to be proposed to the employees as well. So you might want to use something that's really kind of straightforward, like last on, first off. So the employees with the most experience get to stay, and the ones who've got less experience get to go. You might want to flip it around the other way. You can propose any selection criteria you want, really, as long as it's not discriminatory under the Human Rights Act. So you couldn't say my selection criteria is all the guys get to stay and all the women don't, or something like that. Or the old people get to go and then the young people stay. but otherwise you can use pretty much whatever selection criteria you want. So you can come up with some really funky performance matrix that shows you know, their performance ratings over the last X years or whatever. The more complicated it is, the more complicated it is and difficult it is to compare apples with apples. So the easiest is something that's really kind of clear and obvious, and everyone knows where they stand, which is why I guess last on, first off gets used so often, is that there's no debate about that. No one has an argument about whether they should got a 5 or a 4 for that particular performance thing. It's really obvious. It might not achieve the result that you're looking for though, that's the danger. You need to identify who could be affected. As I said before, don't forget about the people who might have a change to their job. So not just the people who might potentially lose their job, but the people who might have a change to their job as well. Good idea to put the proposal in writing in some format, just so that you don't have an argument later on about what was said. There's actually no legal requirement to do it in writing. It's just a matter of evidence afterwards. So you might, I don't like having arguments that I said this, you said that. It's just kind of dumb. So if you can put it in writing, so much the better. And that should include a sort of overview of what the process and the timetable is going to be. Once you've got your proposal, you're going to need to put that to the employees. So you're going to need to meet with the employees in some configuration or other and explain to them what you're proposing to do and why you're proposing to do it. And you're going to need to provide them with information about that. So if you say, we're on the skids, the business is terrible, we're losing money hand over fist, you should expect rather to be ready to provide information in support of that. So just saying we're on the skids probably isn't sufficient. And I guess that's when you're thinking about why you're proposing it. If you don't want to be providing financial information to your employees, you need to think about a different reason for why you're proposing that restructure, because whatever proposal you put forward, you need to provide information about that. You're then going to allow each employee the opportunity to provide feedback and present alternative proposals or suggestions. So you tell them what you're proposing and why, and you say, haven't made any decisions yet, we want to hear your feedback, come back to us with if you think this is a good idea or a bad idea, if you've got a better idea of how we can achieve these aims, if you've got an alternative structure, we're all ears, come to us, let us know what you think. Most of the time, what the employees say won't change what you proposed. Every now and then, maybe like 1 time out of 10, the employees' feedback will make a difference, and I love it when that happens because it sort of shows that the whole process is actually worthwhile, and just occasionally an employee will come up with something that the employer hadn't thought of. And I mean, the employees are the ones doing the job, right? So if the employer comes up with a proposal that this person could do all of these tasks, the employee is probably going to be in the best position to say, actually, that's an insane idea. I'm already absolutely swamped. No way could I take on this, that, and the other thing. And that will hopefully avoid the employer making a terrible mistake. The employee can seek advice and representation through the process, so you need to let them know that they can do that, and don't freak out if they do want to have somebody with them. If there's a union involved, make sure you tell the union. Your collective agreement will provide for that. Unions get really, really hacked off if you don't tell them that there's a restructure on the cards. Once you've got the feedback from the employees, you actually need to consider it, and you need to be seen to be considering it as well. So if you receive all the feedback on a Monday and you are making the decision at 9 AM on a Tuesday, it's not really going to look like you've considered all of that feedback. The amount of time you need to take will depend on a bunch of factors: how many employees you've got, how significant the feedback was. If the feedback requires you to go and do more investigation, then it's going to take longer for you to consider that. Sometimes employees will just go, oh yeah, I get that, sweet. I'm sad that I'm losing my job, but I understand why you're doing it. There's not a whole lot to consider in that. It's not going to take you all that long to consider it. But if they come up with a whole alternative structure and a different way of organising things and question your figures and what have you, that's going to take a lot longer. Once you've got that all sort of nailed down, then you need to make a decision. Are you going to go ahead with the proposal in its original form? Are you going to change the proposal slightly? Are you going to abandon it entirely? And I have had situations where employers have gone, actually, no, this really isn't going to work, flag it, and we'll stick with the status quo. And you need to let the employees know what your decision is. If a position's going to be disestablished in the restructure, are there any other alternative positions that are available such that the employee won't have to be terminated? So you might be looking at an existing vacancy, so a role that you've got vacant for some unrelated reason, or there might have been a new role created as part of this restructure. So in our two North Island manager, South Island manager, disestablish those, create a new role. You've got a new role that these two could potentially apply for. If it's a role that's sort of lower, for want of a better description, than the person who's the position that's just been disestablished, you need to think about whether that new role is within the employee's skills and experience and capabilities. And if it is, that role should be offered to the employee as a way of avoiding their redundancy. That's probably all I want to say about that for now. And then the last step is that if you are going to make somebody redundant, you need to think about all of those sort of practical matters at the end, and you need to talk to the employee about that. So you need to be talking about the timing of it, how much notice they're entitled to under their employment agreement, whether their employment agreement provides for redundancy compensation. If there's no redundancy compensation in their employment agreement, there's no entitlement to redundancy compensation in New Zealand. Having said that, you need to check and make sure that your company doesn't have policies that provide for redundancy compensation. Sometimes we find that there'll be a global policy that provides for compo, even though the New Zealand employment agreement might not cover that. With the notice of termination, you need to think about whether that's going to be worked out, or whether the employee is going to be paid in lieu, or whether there's an opportunity for the employee to be on garden leave. And usually that'll be up to the employer to make that decision, but you should talk to the employee about that. So, hey employee, we're thinking of paying you in lieu rather than having you work out that notice. What do you think about that? See what they think. Some employees prefer to work it out so it doesn't look weird. Other employees are like, nah, just give me the money, I'm out of here, I'm done. So yeah, you do need to talk to the employees. That was a whirlwind of redundancy process. Are there any immediate questions arising out of that? Anyone in the room or online?
I'm just wondering, the last example which you've just explained in terms of compensation you're getting and making the employee work up to the very end. What happens if this employee goes straight away into sick leave? And you actually cannot have this discussion anymore due to the fact that one-to-ones are cancelled, emails are not responded, and so on.
Yeah, so it's really difficult when an employee doesn't engage in the process. So is this after you've made a decision terminate, or you're trying to get through the consultation process.
At the end of the
At the end,
process,
yeah.
So that the decision still is taken.
Yeah.
You know, according to.
Yeah. I mean, you can only do what you can do. So if you can't communicate with your employee, you need to try as many methods as you can to communicate with them. So you might want to send them an email so that you've got a kind of paper trail of the fact that you're trying to communicate. Even text messages are evidence that you've tried to engage with them. Hey employee, I want to have a meeting with you to talk about working out your notice. Can you please call me back? Is a great way of showing that you have actually tried to engage. I mean, worst case scenario, if you've got the ability to pay them in lieu of notice under the employment agreement, I'd be probably exercising that option and just cutting them loose and deciding to pay them that month or 2 weeks or whatever, and not have to deal with the issue anymore. Yeah, it's really difficult when people won't engage, and it's particularly difficult if they're on sick leave and if they've got a med certificate as well, because you can't, unless you've got some reason to look behind the medical certificate, you kind of have to take it at face value. So yeah, it can be difficult, and it's a fine line as well between not pretending, it sounds terrible, between being a caring employer who's not kicking some poor employee who's been made redundant and is sick while they're down, and having an employee take the mickey and mess you around. So it is a really difficult balance to strike there. Yeah.
You have to wait until they finish with the kind of their second to work, like say there's that kind of.
Yeah, I mean, ideally you would. Ideally, particularly during the consultation process, you would wait for them to get better before you continued. So you should always be prepared to bust out your timelines a little bit to accommodate someone who is sick or is trying to get advice from a lawyer or can't have a representative there or whatever. You do need to be a bit flexible with your time frame, but there gets to a point where, like I say, they're just kind of taking the mickey, and at those times you might just have to box on and do it in writing or as best you can on the phone or whatever. It is tricky though, because you don't want to look like a ogre. Yeah.
Any more questions?
Yes,
Oh, yep.
Is New Zealand differentiating between technical redundancies and economic redundancies?
So technical redundancies being where a company's bought, or what do you mean by a technical redundancy?
Skills would not match anymore, or the job is developed, into another direction, and there would not be a fit between employee anymore and the technical skill set which is given.
You're getting into dangerous territory there, because as we said at the start, the redundancy should be about the position rather than the qualities or the skills of the person within the position, and those situations are really, really difficult. So you'd be trying as best you could to be focusing your proposal on the role and what role you need, and allowing that person to apply for a new role. But you're going to need to make sure that that new role is in fact different from the role that the other employee, whether the employee was performing. It is dangerous territory there, because what that looks like is that you've got a role where somebody's just not performing in the way that you would like, or doesn't have the skills that you would like, and you're trying to turf that employee out rather than performance managing them and helping them to develop, to have the skills and the qualities that you want them to have. Yeah. Proceed with caution, get advice. Yeah.
Frederic, who is connected on the webinar, is just asking if you can repeat the questions that they asked.
Oh, sure, is the mic not picking it up?
For the
Okay.
last one, I wrote them down, so I was curious.
Okay,
For the next one, that could be.
I apologise for that, people online. I thought that the mic was picking up the questions as well. We'll repeat them from now on.
Okay, so we're ready to move on to the case law. for COVID times. So we only have authority cases at the moment, which the Employment Relations Authority sits below the Employment Court. We're really waiting on Employment Court decisions, but today we're talking about 2 authority cases. The first one being Dove Hospice. This case arose, so Dove Hospice provides hospice services around East Auckland. During the first lockdown in March, they were obviously struggling because they had to close their stores as they weren't essential services. And this then turned into a situation where they could no longer survive, or part of the business couldn't survive. So the applicants in this case, they worked in the retail stores, in human resources, and in communications. When New Zealand went into lockdown, Dove applied for the wage subsidy, which is the government subsidy. I'm sure you all know about it. And the wage subsidy had a whole bunch of obligations that the employer would read through and say, yep, we confirm that we'll comply with these obligations. Unfortunately, over that time, those obligations changed, but there wasn't a clear record for us to be able to check on those obligations to understand what the employer at the time had agreed to, or at a different time when it had been changed if an employer had signed it later. So it was really complicated, and it also confused employers because they thought that somehow those obligations had changed employment law, which they didn't. So employers still had to follow the relevant employment legislation, and a lot didn't. Just jumping back to the general setting at this time, in March, the Employment Relations Authority received 6,000 applications. That was 10 times more than last year at that time, and 90% related to COVID-related employment issues, and 5,500 related to the wage subsidy. So this complex thing with the government's obligations and law resulted in a whole bunch of issues for businesses, and we're still dealing with a lot of those cases now in our work. So going back to Dove Hospice, Dove applied for the wage subsidy and received it on the same day. And then it said to its employees, don't come into work, we can't open, but we'll continue to pay you 80% of your wages. So that was a little bit more than the wage subsidy amount, but obviously not 100% as they'd agreed to in their employment agreement. And then Dove restructured as a result of the loss of work, and there were issues with that restructure, but this case doesn't go into that part. And they told the employees or the applicants in question that you're made redundant, but we will enhance your notice period from 4 to 8 weeks. And then during the latter 4 weeks, we'll provide you with just the wage subsidy. So their wages were reduced even further, but it was still an enhanced notice period. So it was much longer than they had in their employment agreements. The issues that were listed in the authority were described in the following ways. In accepting the government COVID wage subsidy, is Dove released from its obligations to pay wages or salary under the parties' employment agreements and or the Wage Protection Act? If so, is a penalty warranted, and should either party contribute to the costs? So you won't be surprised, or you might be surprised to hear that the authority found in the applicant's favour. It listed a whole bunch of law, which I will, what time actually are we at? Okay. I have time to read. I'll just quickly summarise what the law was that the authority was looking at. So they're looking at how terms of employment cannot be unilaterally varied. So that means if you have, say, a term in your employment agreement, the employer can't just change it without agreement.
If say I'm going to pay you $20, I can't just pay you $15.
No. It also looked at various sections of the Wages Protection Act, which define wages as salary or wages agreed to be paid to a worker for performance of service or work. Another section which where wages become payable, the entire amount must be paid to the worker without deduction. And then section 5 of the Wages Protection Act which provides deductions may be made from wages payable to a worker for a lawful purpose with written consent. Then it also looked at whether wages are payable in terms of Section 4 of the Wages Protection Act will depend on the relevant employment agreements, and if wages are payable in terms of the employment agreements, then any failure to make either full or part payment of wages is an unlawful deduction within the meaning of Section 4 of the Wages Protection Act. So basically it really came down to, it's a very short determination, but what the authority found was that the employees first did not agree to the 80% reduction to their wages, and then they also did not agree to the enhanced notice period, and then in turn they did not agree to just receive the wage subsidy for that enhanced notice period. So there are a whole bunch of issues in terms of consultation there, and they had a nice wee summary of this case at just over the page. They said that the argument cannot succeed on the following grounds, in terms of Dove saying that, well, they didn't perform work during this time because they were all at home, not doing the retail services. It said if the Wages Protection Act was to operate as argued, any non-performance of service or work would release the employer from its contractual obligation to pay wages. As the Court of Appeal held in another case called Spotless, the application of the Wages Protection Act operates within the context of the relevant employment agreement. The parties' employment agreements do not provide for suspension of wages or salary for non-performance in the circumstances faced by Dove. This part of the determinations alluding to a clause we would call a business interruption clause or a force majeure clause. They're very untested. During the COVID lockdown, we were advising on these clauses, but because they are untested, it is hard to say that if you had a clause that said, in the event of a pandemic, we are able to reduce your wages to 50%, or we're able to terminate you, or we're able to put you on leave without pay. It's very hard to know whether you could rely on such a clause, but it seems to be alluding to that kind of clause here. It'll be interesting to see whether there's any cases that come out about the interpretation of such a clause. But the authority also said that Dove's proposed interpretation of the Wages Protection Act definition of wages stretches the statutory language too far. And it also said, on the unchallenged evidence, the workers were at all times ready and willing to work, but for the intervening event of COVID restrictions and or the Dove's decision not to require them to attend work during the notice period, on the evidence, they were able to fulfill their obligations under the employment agreements. So they're basically saying, while the employees were sitting at home, they were all ready to go and work if the stores were open. It's unfortunate for Dove in this situation because it wasn't its choice to close the stores. It was government direction that they were a non-essential business, so they had to close. This case is being appealed to the Employment Court, so we will wait to see if that determination changes at all. This is a very small, light determination, which is unfortunate because there's not the analysis that we would usually like to see in such cases, so it's hard to provide advice on.
Interesting issue, and really the authorities just kind of going, oh, yep, they're ready and willing to work, and everyone's kind of gone, were they really?
Yep.
They sort of were, but
so we'll see what happens with that under the appeal. This second case, Gate Gourmet, is very similar, except Gate Gourmet provides in-flight catering services for domestic and international flights. Obviously, during the lockdowns, the aviation industry internationally has really taken a hit. So Gate Gourmet had very little work to offer its employees. It decided that the majority of its employees won't work during the lockdown, and it also then applied for the wage subsidy. It then sent out a notice to the employees who weren't working that they could take, providing a bunch of options to them. So the first option was the employees could take all their annual leave, and then once they'd exhausted that, move to option 2, and that was if Gate received the wage subsidy, the employees would be paid 80% of normal pay. And then option 3 was if they received the wage subsidy, pay 80% of normal pay, and use annual leave to supplement the income to 100%. The employees in question were all on minimum wage, so being paid 80% of minimum wage meant that they went below, which was in breach of the Minimum Wage Act. But still, at the time, options in 2 and 3 were agreed to. And the authority has set out the issues as follows. Is Gate obliged to pay the applicants whether they were working or not at least the minimum wage? Was Gate entitled to pay applicants 80% of the normal wage in a situation where this reduced their pay to 80% of the minimum wage? Has Gate breached the Minimum Wage Act? What effect, if any, would an agreement of the parties which breached the Minimum Wage Act have? So I've already revealed the ending of this, but you can't contract out of the wages of the Minimum Wage Act. So even if both parties agreed, which I think is disputed in this situation, that they did agree to contract out of the Minimum Wage Act, it doesn't work. So you couldn't pay the employees who weren't working, but they were really willing and able to work, 80% of minimum wage. But in this case, the authority still said that Gate didn't do this maliciously, so no penalties were awarded against them. They were just told to back pay the difference. Yeah, so it's a very similar case to Dove, but in this situation, it was Gate's an essential service. It made a choice to shut down some of its operations. It could have run a redundancy situation, didn't do that. If it was wanting to get rid of employees, but instead it made obligations under the wage subsidy and to employees that their work would continue. And so they didn't do so well.
And it's never a great look to pay under the minimum wage, obviously.
It's a very small amount of money already, so 80% is not great. So those are the two authority cases. They're very light in detail, and the Dove one is being appealed. So we will watch this space, and no doubt we'll be writing an article on our website about the Dove appeal. Yeah. So any questions emerging from those two?
Not really related to this case, but I was wondering, did you have any case where someone was made redundant and 3 months later the situation improved in the company and they found out that a new position is open and the company actually hires someone when the previous guy is still looking for a job, or and what is this guy then able to complain about that?
So the question is, if somebody was made redundant because of COVID and it all looked terrible and awful and the situation was dire, but then the situation got better and the position was replaced within the company, but the original person found out about that.
We've had this situation before, but before COVID, and sometimes people just genuinely make mistakes when they're running through a redundancy consultation process, and they just genuinely, the redundancy's genuine at the time, but then later they've realized how key that position was to the employer. In those situations, it is complicated, because if that person who was made redundant finds out that someone else has been hired, then they might raise an unjustified dismissal claim. Sometimes we'd recommend to employers to consider approaching that person that they've mistakenly made redundant, and to just get them back, essentially, not make them go through the full application process. But also the risk is, if you do that then they're alert to the fact that you've made a mistake, and if they're feeling very disgruntled, they might still want to raise an unjustified dismissal claim. So it's difficult.
There is no obligation for the employer to open the role to the person that has been made redundant.
There's no legal obligation to open the role to that person. It would only be a tactical or a strategic decision to do that, or a benevolent thing to do, that you made somebody redundant and then the situation changed, which, I mean, it does from time to time, right? The situation can change. and you realise actually, oh crap, we shouldn't have made that person redundant after all, it would be a nice thing to do to go and check on the person that you've just made redundant and see whether they still need a job, because happy days, terribly sorry we made this awful mistake. It was based on the information that we had at the time, but stuff's changed and we'd be thrilled to see you back.
It probably can also be more cost effective rather than having to train someone new.
For sure.
Get a recruiter.
Yeah, absolutely. Yeah, that would definitely be, there'd be a lot of reasons in favour of tracking down the employee who you'd let go. Yeah. Should we tag team this one, anyways?
Yeah, sure.
So, I mean, it's all a bit dire and depressing. I realise with redundancies and the wage subsidy and everything. One of the positives to come out of this whole scenario has been a real increase in flexibility for people to be working in different ways. And one of the really common ones is working from home. And obviously we were, or many New Zealanders during the lockdown were in a position where they were able to work from home, and that might have been something that they hadn't done before. What we're having now in the sort of wash up from COVID is employers wanting to put a little bit more structure around working from home arrangements and flexible working arrangements. And yeah, that's, I guess, a really good idea to have some structure and to have some plans in place so that everyone kind of knows where they are. Because some of the issues are around health and safety when somebody's working from home, the costs of working from home, how you're going to deal with stuff like confidentiality, privacy, the equipment, and the policies that you have. I'll do this one, you do the next one. Yep. Cool.
This one.
Yep.
Okay.
So in terms of health and safety at work, when a person is working from home, they are still working and they are still at work, and there's definitions in the Health and Safety at Work Act that make it really clear that it doesn't matter where you're working. If you're working, it's a place of work. So the employee's home is a place of work. That creates a bit of a challenge for the employer, because the employer has only got so much control over the employee's house or the employee's home, right? There's only, some things that they're able to do in respect of their employees' houses. So it is something that's worth spending some time thinking about. One of the ways that quite a few of our clients have chosen to deal with it is coming up with a kind of checklist scenario whereby you look at all of the risks and hazards that an employee might face when they are working from home, in exactly the same way that you would assess the risks and hazards of an employee working in your office or in your factory or in your production area. So you're looking at what could go wrong, what equipment they're using, what processes they're following, and how that could result in an injury to somebody. And then you're trying to figure out ways to make sure that that injury can't happen. So it's exactly the same when somebody is working at home. You're looking at all the things that could go wrong when somebody is carrying out their work from home. And you're making a list of those things to say, well, these are the risks that we've identified, and these are the things that we want you to put in place to manage those risks. Most employers are not going to insist on rocking up to their employees' houses and demanding to be taken to their spare office or the spare room or the dining table. It was for me. Plenty of people working from their bedrooms. It's really not that appropriate for the employer to be demanding access in those circumstances. To a certain extent, the employer is going to need to rely on the employee, but you can put guidance around that. So rather than saying to the employee, hey, can you just check that your work from home setup is cool? You need to give them some indicators as to what cool looks like and what risks that they should be looking for, and some ways of managing those risks. Some employers are working on a sort of photo basis. So can you please send me a photo of your work from home setup? Can you send me a photo of your smoke alarms? Can you send me a photo of the cord being plugged into the wall and there not being 20 other cords piggybacked off the back of it, that kind of thing. That's kind of a halfway house, I think, between barging into someone's home and just assuming that the employee will correctly tick the box. It's, you know, I quite like it. It's quite nice. Other employers are doing a kind of video tour, I've seen. So you hook them up on Zoom or Facebook or whatever, FaceTime or whatever, and get the employee to take you around the areas that they're working. Again, that's sort of less intrusive than a home visit, but better than a checklist. Don't forget about the mental health risks as well. I think there's been I'm quite encouraged by the amount of publicity that there has been sort of coming out over the last few months about the risks of sort of isolation and loneliness and people just getting overwhelmed, and that not being visible in the way that it would normally be visible, because normally we'd see our colleagues and we'd notice that someone was rocking in the corner or whatever. It is really important to treat those mental health risks in exactly the same way as you would treat the physical health risks. So what are the hazards? What are the risks? How could this go wrong? And what are we doing to stop this going wrong?
Ooh, an interesting question of who bears the costs of working from home. So do the employers bear the electricity, internet, Wi-Fi costs, heating, or do the employees? Generally, employers are responsible for providing the tools required to undertake the work. It is a bit ambiguous whether Wi-Fi is the tool. Obviously, we all survive on Wi-Fi for our work, but in this situation, we still don't see employers all paying for Wi-Fi at home, but they might opt in to do so. And if they do, we often recommend putting that in some sort of policy document, including a whole bunch of the other obligations around health and safety, the checklists, confidentiality, etc., etc. And then there's also the point of reimbursement for working from home related expenses. It's the same. It's ambiguous. It's hard to determine what exactly an employee could be reimbursed for. Check your employment agreement. It might have something around that, but otherwise try and work out these things in a policy document for working from home.
We haven't had that many employees complain,
no.
Or I think possibly because the travel costs that you would normally have and the other costs of actually working from a premise are offset, and so people don't feel that stink about having to use their Wi-Fi or their power or whatever, because they're saving $5.60 on the bus fare to work or whatever. So it probably all works out in the end. We do have some clients who have paid a sort of allowance. A work from home allowance. The other thing as well is that sometimes, like, whose idea it was is really relevant as well. So if it's the employee's idea to work from home, then it's a bit rich for the employee to then be saying, and actually, can you pay me some money for power as well? If on the other hand it's the employer directing that to happen, then I feel like there'd be a much better case for the employee to say, well, hey employer, I didn't have to have super fast internet before, and I had a small limit of whatever it is that you buy internet, and now I've had to increase that and it's costing me more. You're making me work from home. Hey, this isn't cool. I'm worse off here. You need to step up, employer. And that feels instinctively a lot better argument, doesn't it? So it is kind of horses for courses a little bit.
Yeah, I guess the same goes for providing a laptop, providing an office chair, providing a mouse. We would, if that's what the employee primarily works on, we'd recommend the employer provide all of those things. But yeah, it's, I guess, as people move to this arrangement permanently, we'll have more clarity in this area, and there might be a few more cases that we can look to. It's just a very new thing that now the majority of us are experiencing rather than just one-offs here and there. So it's again a watch this space deal.
Definitely. As Eloise mentioned before, having a policy, and I think that is my, our last message, I guess, is that all of these sort of elements and these different things about working from home, it's a good idea to bung them in a policy so that there's no argument or discussion about what is fair and what's not, and what the employer's expectations are in terms of things like confidentiality. It can be really challenging for some employees, particularly where you've got, say, a flatting scenario, or you've got a large family environment. If you don't necessarily have a spare office, as I certainly didn't, and I'm working on the kitchen table, if I had a bunch of people looking over my shoulder at my confidential client documents, that would obviously be a real drama. So it's important to cover off those expectations of the employer as well. Ditto with things like productivity and monitoring and employee performance. I think one of WorkSafe's kind of guidelines in terms of looking after people's mental health during the pandemic was don't ride your employees too hard in these circumstances, because it is really, really challenging and everyone is finding it challenging. Don't be expecting employers the same level of performance as you were getting when they were in the office and when we were in normal times. Having said that, it's still really important to keep on top of what your employees are doing. It does involve a lot more trust with your employees, because you don't have eyes on them all the time. So you do need to come up with alternative ways of figuring out what your employees are doing and when they're doing it. And that's about putting just structure around that. Ticking all that off in a policy is a really good idea. So any reporting obligations, letting your employer know when you are sick or when you're not able to work or whatever, is really important. Also, in terms of monitoring, it's really important in terms of the Privacy Act that you let employees know what it is that you're monitoring. So if you've sneakily activated the camera and you're watching your employees at every moment, that's obviously a bit naughty, and you probably shouldn't do that. So you just need to let employees know what sort of level of monitoring you're undertaking and why. So that is probably about us in terms of working from home. Lots of issues need to be discussed between your employer and employee. Stick it all in a policy so you don't have any arguments about it. And our smiley mugs of the employment team are there. What we'll do is send around a copy of the presentation so you can have the information at your fingertips if you're in the unfortunate situation of having to do a redundancy process, heaven forbid. And also in terms of the work from home, just think those things to just kind of tick off in your mind and make sure that your organisation is actually dealing with those things. And if you need any help, you can contact any of our smiling faces and we can help you out. So any questions, comments, war stories?
Yeah.
We are all on mute, so if they
are able to unmute themselves if they want to speak.
We've given them the power. All you people online, if you want to unmute yourself and talk, you are welcome to do so.
Freddie, I'm sure you have some questions. You always have some.
Oh.
So are you talking to me?
Yeah. I was wondering if you have any questions. You usually have some.
Yes, no, actually it was very insightful and informative. So I covered a lot of ground. Very interesting, I think. And some of the questions I had has been answered during the presentation.
Okay,
That's what we like to hear. It just happened organically and seamlessly. That's excellent. Cool.
Maybe one comment. Thanks a lot for this overview. So it was really a very good content. I was actually working with Jody on exactly the wage subsidy topic, which you've brought to our attention. And for us, it was a very smooth process because actually we offered contract addendums to each of the employees in order to reduce the work time and the salary by 15%, so to 85%, while knowing that we get the wage subsidy.
Yes.
And everyone sees in the end the benefit as well of still receiving 85%, while as especially the travel industry, the turnover went down the drain. So I see actually the last couple of months as very positive in terms of employees' appreciation of what the company is doing and the other way around as well.
Yeah, I mean, I think the comment, really sorry, just for the benefit of the people online, the comment has been that I guess reaching an agreement with employees and both parties kind of pulling together, so employees recognising that in this case they needed to take a 15% reduction in their hours and their pay, but that was going to be significantly better than losing their job entirely. 85% is quite a lot better than 0. So people sort of working together, and that's really laid the foundations for moving on from here. And yeah, I think we've heard that quite a bit actually, that where employers have done the right thing, I guess, and have asked employees for a variation rather than just randomly paying them 80% or 60% or 50% or whatever, it's really going to stand them in good stead for moving forward. And it's going to mean that they don't get spanked by the Employment Relations Authority as well, which is always good. Yeah.